Good day and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in today's episode, we're officially kicking off our third season. It's going to be a big year for patents, and we couldn't be more excited about the lineup we're bringing you. Starting in April, we'll be releasing huge interviews with distinguished industry heavyweights, delving into much-needed, meaningful solutions for patent reform. Shortly after, we'll be starting a series of interviews with some incredibly savvy investors to help better understand what investors want in patents. We typically think about the primary audiences for patents being the PTO and courts, but many inventors and startups care more initially anyway about investors. This is a very important perspective. Since it's taking the innovation world by storm, we're also going to take a look at what generative AI like ChatGPT could mean for the patent world. Pulling from some of the most frequent questions we get from live inventor training events, we'll go even deeper on prior explorations into software patenting by looking at the interplay between patents, copyrights, and open source. We're also working on a collaborative effort to do a tangential dive into the world of copyrights and trademarks and the wave of pop culture cases that could have major implications for copyright law this year. And for those wanting to better understand the levers at the heart of patent law, we have a series planned for further exploration into claim types and strategies. But first, in this month's episode, we're leading off with a close look at a Supreme Court patent case that could have profound impacts on the invention enablement problems we covered heavily in Season 2. SCOTUS is set to hear opening arguments in Amgen versus Sanofi on March 27th, so we're leading off with this topic to help get folks booted up who might want to follow along as the case unfolds over the coming months. For the first time in over 75 years, the Supreme Court is evaluating the meaning and scope of the enablement requirement. For those who have been following along, you'll know that this has become one of the bigger issues plaguing patenting, and especially so in the life sciences. Enablement, like its wicked sibling eligibility, have been two grounds for rejection and invalidation that haven't historically been all that common, but are becoming increasingly prevalent in the less predictable arts, like immunology, molecular biology, chemistry, and diagnostics. This is in part due to something called a genus claim, which has been a critical patent feature for chem, biotech, and pharmaceutical industries. Derived from their traditional biological definitions, a genus is a group defined by common characteristics, and a species is a logical division of a genus. In chemical, biotech, and pharma patents, a genus claim covers a group of structurally and/or functionally related chemicals, whereas a species claim covers a single compound without coverage of analogs, derivatives, or compounds in the same family. Why this particularly matters for pharmaceuticals is that one successful drug needs to be able to recoup the massive R&D costs from the countless failures that preceded it, and that requires adequate coverage and exclusivity over a period of time. A lot of drugs would be pretty easy to design around if a patent only narrowly claims a specific chemical species. A competitor would simply have to use a different functional group or additive with the same properties, and bam, they have a new, non-infringing therapeutic based on an R&D investment they didn't make. It would be impractical, if not impossible, to reduce to practice every possible applicable species. The broader genus claims have historically been the umbrella tool of choice for many innovators in this space. Where the genus claims have run into trouble is with the interpretation and court-based expansion of one of the core statutes that governs patentability. This fundamental tenet of patent law is the concept of enablement. When a patent publishes, the information contained in the patent becomes part of the public record. So enablement requirements aim to ensure that society receives something useful in exchange for the exclusive rights granted to the inventor. This is the grand bargain of the patent system. Codified in Section 112 of U.S. Code Title 35 are the minimum requirements for the quality and quantity of information that must be contained in a patent application to justify the grant of a patent. Section 112 basically says that a patent application must describe the invention in full, clear, concise, and exact enough terms to demonstrate that the inventor had possession of the invention at the time of filing. This is called the written description requirement, and to enable those skilled in the art to make and use the invention, or the enablement requirement. A 1916 Supreme Court decision further defined the standard for determining whether the description meets the enablement requirement by raising the question of whether or not the experimentation needed to practice the invention is undue or unreasonable. To this day, even though the statute does not use the term undue experimentation, it has been interpreted to require that the claimed invention be enabled so that any person skilled in the art can make and use the invention without undue experimentation. The big question this all culminates in is the focus of the upcoming Supreme Court case that is the focus of today's conversation. What do genus claims require from an enablement perspective? Will the enablement standard be governed by the black and white codified Section 112 statutory requirement that the specification must only teach those skilled in the art how to make and use the claimed invention? Or will the Supreme Court lean on court-based additions to the standard that the specification must enable those skilled in the art to, quote, reach the full scope of claimed embodiments without undue experimentation? To get genus-level coverage, the latter would require the inventor to actually reduce to practice every single species they intend the genus to cover. And that brings us to the particulars of the case at hand. Amgen versus Sanofi has a long case history that goes back nearly a decade, with the involved parties trading turns on offense and defense, with 2 juries coming down on the side of Amgen, but district and federal circuit court judges ultimately ruling in favor of Sanofi. The battle centers around competing versions of cholesterol-lowering drugs produced by the 2 companies. Amgen makes Repatha and Sanofi makes Praluent, with U.S. sales handled by Regeneron. The drugs are monoclonal antibodies that lower the levels of LDL, or low-density lipoprotein cholesterol, aka the bad cholesterol. Amgen initially sued, arguing that patents protecting Repatha were being infringed by Praluent. Regeneron and Sanofi argued that Amgen's patents weren't valid in the first place. Twice, district court juries found Amgen's patents valid, concluding that Sanofi failed to prove that the claims lacked enablement or written description. Sanofi's subsequent motion for judgment as a matter of law for lack of enablement, however, was successful at the district court level and was later affirmed on appeal at the federal circuit, which concluded that Amgen's claims were invalid on grounds of enablement because, quote, undue experimentation would be required to practice the full scope of the claims. In a rare move for patent law and against the Solicitor General's recommendation, the Supreme Court will now hear the case, giving Amgen a final opportunity to resurrect its patents and hopefully more broadly provide clarity for the industry on the enablement standard for genus claims. Sanofi is arguing that Amgen is asserting a monopoly over an entire genus of functionally defined claims that are not enabled since they cover thousands of possible antibodies, while the application only highlights a limited number of examples. Sanofi's arguments hinge on the Federal Circuit's full-scope enablement standard, where every species in a genus must be reduced to practice. Sanofi believes that beyond the lack of enablement, the functional genus claims and their overly broad protections stifle innovation by monopolizing entire classes of rival drugs. Amgen, on the other hand, is arguing that the Federal Circuit has gone off the rails on enablement laws, that it's defying more than a century of Supreme Court precedent on the issue, invading the jury's role, imposing a full-scope requirement that's not contained in the Patent Act, and is frustrating the purpose of patent law by invalidating patents for breakthrough inventions by demanding disclosure about theoretical far corners. Amgen contends that imposing these standards and invalidating genus claims on perceived size alone will have a devastating impact on breakthrough innovations in biotech and pharmaceutical industries. They state that given the significant investments required to discover and develop new innovative therapeutics, the patents must provide a meaningful scope of protection broader than just the specific examples the inventors disclose. And that void of those protections, the system will encourage copyists, not the next big breakthrough, making it all too easy to create Me Too drugs that only require minor changes and not the same research investment. Amgen's key argument is that their application provides the necessary roadmap for someone skilled in the art to make and use its drug and all covered species without undue experimentation, whether it's 5 or 5,000, and that the law as codified does not require the applicant to include examples for every possible permutation. Regardless of how this plays out, it's hard to imagine the High Court's ruling not having significant consequences for the industry. Their willingness to hear the case alone signals that big changes could be on the horizon, with district and federal circuit courts ruling one way in lockstep, and the Solicitor General recommending that the Supreme Court not even take the case, combined with the fact that the court takes up few cases on petition, and even fewer yet for patent law, there's little reason to believe the Supreme Court would take the case to simply step in and just rubber stamp prior rulings. In any case, the stakes are incredibly high, and there truly is a very important balance to strike in all of this. While broader protection is necessary for life-changing pharmaceutical patents to have any real value, enablement requirements are the check in the system that prevent massive land grabs and exclusive rights for things that applicants didn't actually invent. And I can't think of a better person to help break this all down for us. Dr. Ashley Sloat, President and Director of Patent Strategy at Aurora, leads our discussion today along with our all-star patent panel, exploring the scientific background around antibodies necessary to understand the claims, a brief history of Amgen versus Sanofi, an overview of the enablement factors and tests that have been historically applied in courts and how they might apply to this case, and a discussion around open questions and the potential unintended consequences of the Supreme Court only taking up one half of the two-sided enablement coin. This ends up being a really great, spirited conversation with panel members coming down strongly on both sides of the case with very compelling arguments, really highlighting the complexities and fundamental issues the court will have to face. The group also leads off with a short brainstorming session around embodiment drafting, some dialogue around a lesser-known process for strategically slowing prosecution, and an icebreaker that shines some revealing light into the survival instincts of your beloved hosts and panelists. Ashley is joined today by our always exceptional group of IP experts, including David Cohen, principal at Cohen Sciences, Kristen Hansen, patent strategist here at Aurora, David Jackrell, president of Jackrell Consulting, and Ty Davis, patent strategy associate at Aurora. And if you'd like to help us navigate this complex world, both before and after the Supreme Court discussion, I have great news. Aurora is now hiring for a part-time biomedical sciences patent agent. This is a salaried, fully remote position with a flexible work week and benefits. Work where you want, when you want, with a great team on engaging subject matter, and even get the opportunity to join us on this podcast. Learn more and apply at aurorapatents.com/careers. We'll also include that link in the show notes. If you still haven't had your fill of enablement, I do encourage you to check out several related episodes from Season 2, including Episode 5, Fortifying Life Science Patents, where we explore both eligibility and enablement issues currently confronting life science patents. Episode 8, on Means plus Function, where we discuss enablement standards around the use of functional claim language, and Episode 10, on the unpredictable arts, where we cover practical tips for getting more predictable results when patenting biological, chemical, and emerging technologies. Now, without further ado, take it away, Ashley.
The icebreaker I have for today was, if you could take 3 things to a desert island, what would they be?
Well, could we start with one thing?
Sure.
I was, years ago, there was one of these sort of team building exercises at a company I was working in, and they brought in a trainer, and there was a scenario, some scenario. You were in the wilderness, and it was like this: what item would you take with you? And I said, take a flashlight. And this I've never forgotten. And this other woman in our cluster said, "Oh, are you afraid of the dark?" And this and that. and so anyway, when it came time, to reveal the correct answers, the first thing was a flashlight. So I'm sticking with flashlight for my one eye.
I like it. It does seem reasonable. That would be helpful. That's not the thing I had been thinking, but now I'm reevaluating.
Right. I mean, for this second and third, I would take extra batteries. That's what I would do.
I'd take a water filter and sunscreen.
Fair.
I don't know about the third.
When I first read it, I was thinking much less practical. So I was thinking,
bikini.
I was thinking a guitar, because endless hours of entertainment.
What do you do?
But, something to make fire would probably be. I think that it's not quite as good as a flashlight, but you can also cook food with it if you happen to catch any fish or anything.
Yeah.
So maybe a guitar and flint and steel. There you go.
I like it.
I think I would cheat. I'm going to say 3D printer, but I'm also going to need the computer, CAD software, and electricity. Oh, and endless filament, of course.
Yeah. How do you order more?
Yeah.
Or,
like
maybe
solar-powered 3D printer and like 20 tons of filament.
Yeah.
Or maybe the ideal answer is like a fully charged sat phone, Get off of the island.
Yeah. I don't need the other two because I'm getting out of here. Yeah, I was thinking a warm blanket because I'm very cold, and even an island I feel like would be cold at night. So I would want a warm blanket. But then the water filter also occurred to me, but I was thinking maybe some kind of machete, because I don't know what's on this island, kill something to eat, or I don't know, make a shelter, cut down some branches. I don't know. I've seen Survivor. You need some stuff, right? naked and afraid. So
Yeah, exactly right. Duct tape.
yeah, duct tape. A boat to get off the island. Kristen's end. A flare, a satellite phone, and a boat. Well, it depends how tropical it is. I mean, if it's like really tropical, I don't know. It could be persuaded to stay. All right. So strategy tidbits, problems, practice issues, technical issues. I have a just a random thing I learned to share. But does anybody else have any thoughts, comments, insights?
I guess I wonder, do people put an embodiments section typically in their application? The sort of at the very end where you list out all your claims in narrative form. Is that standard? Does everyone do that?
We've been doing it more and more, especially for particular clients. I mean, the summary kind of suffices that for a while, but now kind of been putting it at the end.
If you're going anywhere outside the US, you really do want to pay to have that in there.
Right.
There's a lot of software that'll auto-generate that for you as well, but it's just becoming more important for European practice, I think. I've been stuck a handful of times where I can't get a claim from further down my claim list because it's from a different embodiment in my spec.
Right.
And so doing those permutations of embodiments has been helpful.
So another thing I've noticed is some people, rather than dependency, rather than going back to a particular embodiment or claim, they'll say any of the above.
Mm-hmm.
Do people? What about that one?
I think that holds less weight in Europe. We went through an opposition proceeding with a client, and those kinds of statements, especially like early in the spec, for whatever reason, at least the opposition division kind of viewed that as almost like a summary intro section and didn't give it as much weight. I think there's still value in saying like other parts in the spec saying, this could be applied to any of the other devices. For example, any of the devices of figures 1 through 10, because you're kind of being a little bit more specific there. But at least in my limited experience of how at least the opposition division views that, it's for whatever reason given less weight.
I see.
Yeah.
Ashley, Ashley, did we have a client that said any of the above embodiments, and in particular the embodiments of examples 2 through 4, and they were kind of more specific in that way?
Yeah, that was in an example embodiment section at the end.
Yeah.
Yep.
Mm-hmm.
Yeah,
That's exactly what I was going to say.
At the end.
I've seen that happen. Right.
So you would say any of the above, but in particular this and this and this, and sort of have it both ways.
Yeah. I don't know if it works. I haven't pushed that through, but.
Oh.
And I think the other thing I've seen from like even just a mixing and matching embodiments, again, from the same prior opposition proceeding, was that, especially in the chemical sciences, you get a whole bunch of lists of things, right? Like the first polymer could be any one of laundry list. The second polymer could be any one of laundry list. And
Right.
Europe allows you to choose one from one list, but not choose 2 from separate lists. So you would have to have a section that said, the first polymer is this, and then the second polymer could be chosen from this list, or the first polymer is this, and the second polymer could be chosen from this list. And so you can't, they don't like, I'm sure there's some statute somewhere in their coding, but you can't choose multiple species from multiple lists. You're only allowed one laundry list from a species selection. So if, where this client ran afoul of it is that their technology had developed substantially over time from that really early filing. And so while they had coverage for it, it was covered in the laundry list, whereas like the true technology laid in other polymers that they hadn't really fully reduced to practice yet, because at the time they thought that, these 2 polymers were the thing, but then their technology evolved where the one polymer was the same, but the other one had changed. And unfortunately, the way it was all crafted at that early date, you kind of had to select from 2 different lists to make it work. And they didn't like that.
Do you think part of the problem, let me just say, so do you think that part of the problem there was filing too early? Or was it just life?
I wasn't part of that original decision. I mean, I think at the time, like, it does work. Like, what they were doing did work. I think they might have moved away from it, for like more flexibility. Yeah. And I think maybe cheaper manufacturing of their product, I think. So it's hard to say because I wasn't there at the ground floor of like kind of what they had at that time. It was fully enabled, I think, though, and stuff like that at that time. So I don't know. Yeah, it's hard to say though. Like, should they have waited a little bit or something and maybe captured other embodiments, or fully reduced them to practice?
And this relates a little bit to the Amgen case we're going to talk about today, right?
Yep,
Yeah.
exactly.
With these long lists. And do you even have protection for such long lists if you don't have data on all of those combinations, interesting questions.
Yeah. Which I don't know if we'll answer today, but we can try. The only thing I came across that was, I've always historically kind of had the view that you can't slow prosecution. Like, you can expedite prosecution, but you can't slow it down. But I came across this, and it looks like there is a way to suspend activity on your case. And actually, I think Intel is one of the biggest users of this. But you can actually ask for suspension for cause, just, obviously cost a petition fee. You can't have an outstanding action item, or you can do some kind of limited suspension of action after an RC. A CPA isn't as common anymore. And then for a processing fee, but that's only a 3-month delay. And then you can defer examination, not exceeding 3 years, cost the processing fee.
I think that deferral of examination is 3 years from the earliest priority date.
Okay, good to know.
And
it's not like 3 years on every continuation. You know what I mean? It's very limited. Yeah.
And the cause can catch you up. I mean, it has to be definitely for cause, and the reasonings are pretty clear.
What are if you all have seen this before, what are the causes that are?
I'd have to look it up. I don't remember, but I remember them being kind of strange stipulations.
So these are codified causes.
It could be, there could be business causes too, right? I seem to recall something about cost. Something is happening with the business and there's a reasonable cause to delay, and it was fee related, and not because you couldn't pay the fee or pay the counsel to do it, but because something else was going on in your business. But I don't remember exactly. I'd have to look it up.
Yeah, interesting. Okay. And then obviously the office can suspend activity on cases for various reasons. I think we've seen a lot about the Hyatt cases where his patents have been pending for a long time with the suspended activity. So, but anyways, so interesting piece of tidbit. So you can slow it down. All right. So getting into the meat of today, says Dave, as you already alluded to, kind of talking about Section 112. Particularly written description, enablement, and not really best mode, but best mode's in the same paragraph, so it's kind of in there. But just kind of give everybody a reminder of what the statute actually says. It says the specification shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains or with which it is most nearly connected to make and use the same, and shall set forth the best mode contemplated by the inventor or joint inventor of carrying out the invention. So I've highlighted, obviously the written description, the kind of qualifying statement there is manner and process of making and using it, enablement, clear and concise terms to enable person to make and use the same, and then like I said, best mode. So the conclusion that I come to, and you'll kind of see, and, be interesting, the dialogue here. I have some questions at the end to kind of spur some thoughts and deeper thinking on it. But I almost feel like, and there's some great quotes from former Chief Justice Rader in a dissenting opinion on I think a 2010 case about this too, which I fully agree with, that, maybe enablement and written description really shouldn't be separate. Can they really be separated? I think some of the reason why it's stated the way it is, I think the original intent was that, written description, you prove possession of the invention, whereas enablement is more to teach somebody a skill in the art how to make and use the invention, kind of that whole promote the progress of the useful arts. And then best mode, right? You can't keep the best mode for yourself. But, I feel like, I know there's a lot of, like, if you look online, there's tons of analogies around how you could, in theory, prove possession, but not teach someone how to make and use it. But I don't really think you can. But anyways, we'll go through the court case in detail. I have a few things I've pulled for the district court part as well. But again, really curious about y'all's dialogue about it too. So the overview, I start with In re Wands, partly just because this is kind of where some of this all began. This is where the Wands factors come from. And interestingly, Wands was a antibody case. And interestingly, 30 plus years later, we're back at an antibody case, still talking about enablement, and can't seem to figure it out. We also talk about the written description test. There's 2 tests that can be used to identify whether a written description is, it meets the criteria of the written description. And then we'll talk about Amgen versus Sanofi, and talk about some background of PCSK9 and the LDLR receptor and the antibodies that they were developing at that time. And then again, questions for discussion that these are things that kept going through my head when I was working through this, but, again, curious what everybody thinks. So in re Wands, the whole purpose of the Wands patents were to create an immunoassay to detect hepatitis B surface antigen. So obviously, hepatitis B, bad deal, would be great if you could detect it in immunoassays. The interesting thing is that they were trying to get IgM antibodies instead of the typical IgG antibodies, which are used for immunoassays. So as a quick primer on antibody basics for anybody who doesn't know antibodies.
Thank you.
Yeah. they're quite little miracles. Harkens back to my love of immunology, but so there's 5 different kinds of antibodies or classes of antibodies. And you can see that this bottom piece is the FC region. It's relatively static. And then these are the variable regions, which are the things that bind antigens, epitopes in the body So IgG is probably the one we think the most of. This is the antibody that crosses the placenta because it's small. This is the antibody that's really the workhorse of the adaptive immune response. So when your, immune response is in full gear and, you're trying to kill cells that are infected with a virus, a lot of the IgG is the workhorse of this. Exists in serum and monomeric form. So that's like the main one that I think most people think of. But there's also IgM, which is a pretty powerful antibody too. It's the earliest antibody that's created. It's usually in pentameric form. So 5 of them are kind of together. And that's why it doesn't traverse the placenta because it's freaking huge. But it's also involved in activation of the complement pathway. So that means that like a garbage collector of the immune system can come and bind the FC region of IgM and then kind of engulf whatever is attached to it. So it's really great for kind of killing things that need to be killed once that antibody binds to it. Not to say that IgG can do it, but IgM is a good fixer. IgA is your mucosal surface antibody. It's secreted a lot in your mucosal surfaces as a great frontline defense at your epithelial cells to attack viruses and bacteria. It's a good neutralizing antibody. IgD, it's never been known what it does in all the years. We still don't really know what it does. It's expressed on immature B cells. What it does, it's probably needed. I'm actually curious now if somebody ever did a knockout mouse of IgD and what happened. But anyways, we don't really know what IgD does. It just kind of hangs out there. And then IgE is your like histamine allergic reaction antibody. So that's, involved with cells, with activating cells of the more allergic reaction. So eosinophils, neutrophils. But for discussion today, we're most curious about IgM in re Wands and then IgG for Amgen v Sanofi. So anybody have questions about antibodies?
I mean, it's kind of something that jumped out at me about the Amgen. One of the Amgen claims is they talk about these antibodies and these epitopes And then one of the dependent claims is wherein the epitope is a functional epitope, which, as in patent terms, that really jumped out at me like, functional is like a big keyword, obviously, right? But is that a standard bio term that someone would know, like, oh, this epitope is non-functional and this epitope is functional, or is that like a standard biological term, or not?
The way I would interpret that is that, so epitopes are the things that antibodies recognize. And, honestly, I don't think we know enough about antibodies and the cells that produce antibodies to make an educated guess about what thing they're going to bind on what, that's why vaccines are hard to make, right? That's why, it's hard to, you'll see from all the research that Amgen and Ray, and Wands did, it's really hard to get an antibody, to find an antibody that is specific for a thing. So when they say a functional epitope, what it says to me is that I'm sure there's tons of things that antibodies bind that are not functional, but it's a way to tag something and then engulf it, neutralize it, change it, whatever. But that, just because the antibody binds like over here, doesn't mean it's going to necessarily block a receptor from binding, but maybe because that antibody bind over here, it's going to cause some other pathway to kick off over here, but it didn't bind a functional epitope of the protein. So that's how, so for the PCSK9 protein, clearly it has ligand binding activity, right? It binds the LDL receptor and causes it to be internalized and degraded. Yeah. But in theory, other antibodies could exist that bind PCSK9 in other areas that maybe block binding to HDL or actually LDL proper and not the receptor, which I have a diagram of that too. Okay. So that's what I would say, from a functional epitope versus, other epitope. I think a lot of parts of proteins have a function. We just don't know what they are and how to tease it out, because the things are a lot of compensatory things. And then, proteins change shape when you start messing with their amino acid residues, but maybe they're still kind of functional for some things. And, we just don't understand. That's part of my beef, I think, a little bit with the court's handling of Amgen, is that I think a lot of like the so-called unpredictability is just inherent in physiology. It's not, I think they did a good job probably of guiding somebody about how, and antibody science has been around for decades, so I think that's well vetted out. I think it's more the fact that like physiology is hard and physiology is unpredictable, but I don't think we should be preventing companies from creating therapeutics just because physiology is hard and we don't fully understand everything, even in a very non-nascent field. But
when you say functional, maybe ready to do the function that you're talking about in the claim. So primed or set up, or I'm still kind of struggling with just the concept, but
yeah. So, in the PCSK9 claims, they were very particularly, I think, interested in, I think I have the claim somewhere here in the.
Yeah, sorry to jump ahead.
No, it's okay. They're interested in the areas they're interested in blocking PCSK9 binding to the LDL receptor. So it's going to be any functional epitope that would otherwise promote PCSK9 binding to LDLR. So it's going to be a pocket in PCSK9 that binds to LDLR, and they basically want to create something that prevents that from happening.
Okay. Yeah, that is interesting language, though, David. I agree. Mm-hmm. That would send me for the hills. Like, don't say that in a claim.
Right. Okay. And then so antibody design, because there's a lot of talk about, antibody design. So this was, again, antibody design has been around since like the 1970s, and probably actually it was well known in the 1970s. So it's actually, I think, been around probably for a better part of a century, honestly. But typically what happens is you immunize an animal, typically a rabbit, with your protein of interest or an epitope of it and lots of adjuvant. It's usually some kind of bacterial products that ramp up the immune system, because the immune system isn't going to react to just a random protein fragment. It needs something to ramp it up. So, sometimes it's like a lipopolysaccharide piece from a bacteria, or it can be all sorts of weird things and adjuvants. So the idea is just to ramp up the immune system. And then, of course, your immune system gets ramped up. The B cells start secreting antibodies. And of course, it's like lots of antibodies, right? Because it's not only antibodies to your protein or different parts of your protein, different epitopes, but it's also to the stuff in the adjuvant. It's, a whole bunch it's a mixed bag of things. And then you eventually isolate those lymphocytes. If you put lymphocytes, basically, white cells out of blood, if you put them into a tissue culture dish, they're going to die. They're not immortal. But so what you do is you fuse them with tumor cells, usually some kind of myeloma cells. You put them into specific media where it kills anything that hasn't fused. So you get these fused hybridomas, as they're called. And then you usually do some kind of screening mechanism to try to find the ones of interest. And so, there's you basically do a limiting dilution assay to get one cell per well. And then you do some kind of binding assay to see if it, is binding to the thing of interest. And then you would expand the selected clones and probably do more testing, right? To see, in this case, how much it bound to your particular, it was a high affinity antibody, low affinity antibody. Is it, what kind of binding affinity does it have? Whatever, maybe what epitopes does it bind to? What's it actually binding to? So that's kind of the general process. But again, this was well known. It was stated in Ray Wands that this was well known at the time of filing in Ray Wands, and that was in the late 1970s, I think. So now we're plus 30 years after N. Ray Wands. So now antibody technology is really well known, right? Because you have 30 plus years plus all the years pre N. Ray Wands. So I think we can say that antibody design and screening is quite well known. So in general, N. Ray Wands, and for those who didn't know what N. Ray meant, it just means in the matter of. So in this case, there's no defendant because it's just an appeal from at that time, the Board of Patent Appeals and Interferences, which is now the PTAB in a slightly different form. But it was just his appeal from that decision. So there was no defendant. There was no infringing party or anything like that. They just didn't like what the BPAI had said. So the suit was brought by two of the three inventors, Jack Wands and Vincent Zorowski. And basically their patent was upheld. So what the Federal Circuit has said at that time was that they had provided sufficient experimental support for the breadth of the requested claims in the context that experiments in genetic engineering produce at best unpredictable results. And I love that quote because that encapsulates my frame of mind a little bit with all of this, is that, your genetic engineering, you're trying to get B cells to produce something. And at best, you're going to get unpredictable results because of just the nature of how it, like I said, you're injecting something into an animal that's just not your protein. It's a whole bunch of other junk to rev up the immune system. So trying to find the needle in the haystack, that's what's always going to be. Oh, and just one other stat about this. I looked this up because I remember it being a crazy frequency. So in a limiting dilution assay, so the frequency of a B cell that is specific for your epitope of interest, so your protein fragment that you put in the injection here, the average frequency is 0.05 to 0.005% in the normal B cell repertoire. So when the B cell spits out all these antibodies, your antibody of interest, it's going to be a mixed bag, right? Probably it's 0.05 to 0.005% in a normal repertoire. So to put that into perspective, it's not a lot that you're looking for. And then the other part that was interesting that the court had said regarding the Wands patent, it provided considerable guidance, high level of skill in the art, methods needed were well known. And so again, kind of encapsulates that kind of, the pieces were there and it was upheld. So the Wands factors came from this. This is our test for enablement, quantity of experimentation necessary, amount of direction or guidance, presence or absence of working examples, nature of the invention, state of the art, relative skill of those in the art, predictability or unpredictability of the art, breadth of the claims. But there's also a separate test for written description. And, this kind of dates back to this Regents of University of California versus Lilly and Co. And I couldn't even in this case find the explicit stating of these two tests, but it kind of picks up in later court cases that these are two tests that are used. And you actually see it in Amgen's case as well. But they have a representative species test. So do you have a representative number of species that fall within the genus, which we've kind of heard this and been talking about this. And then are there structural features common to the members of the genus so that one of the skilled in the art could visualize and recognize the members? So I think, again, that's things we've been talking about, right? Is there some common feature amongst all of these? And then do you show a representative number of species that are captured by the genus? So again, fast forward 30 plus years, still in antibodies, but this time it's Amgen versus Sanofi, Federal Circuit 2020. And this, and I'll give some background around the bouncing around with the court, but the purpose of the Amgen patents were to produce an antibody to bind PCSK9 to prevent it from binding to LDLR to reduce LDL cholesterol levels. So remember, LDL is the bad cholesterol, HDL is the good cholesterol. And so when you have PCSK9, it basically, binds the LDLR receptor, and I think basically promotes more LDL receptor from materializing. But there's also been studies that show that PCSK9 can also bind LDL and can also bind HDL. And the purpose of that is a little bit less well understood. But the whole goal was to have, when PCSK9 binds the LDL receptor, it prevents it from being able to bind LDL. Whereas if you can block PCSK9, then you can get it to bind LDL. And so you can kind of get rid of LDL in the system. So with monoclonal antibodies, the whole goal of their Repatha antibody, which was the subject of their patent, was the idea to create antibodies to bind PCSK9 to prevent it from binding to the LDL receptor. But again, might have other effects, other binding domains for other things like HDL and LDL.
Yeah, let me just. It's more than just bind. The purpose of binding is to internalize it. So ultimately, the goal is to prevent the internalization of LDL.
Right. So it can actually bind with, prevent internalization of LDLR receptor or the LDL receptor, right?
Right. The receptor and the LDL, I think, are internalized together. So
yes, when they bind together, but when PCSK9 binds, it's also internalized, but then it's degraded into the lysosome.
I see. Okay.
Destroyed.
I see. Right.
That was kind of the hope, and they developed a whole product line around it, Repatha. So this was kind of the bouncing around that happened. They went to the district court. At the first pass, the patents were found to be not invalid for lack of written description and enablement. The patents were found to be not obvious, and there was found to be no willful infringement. But apparently Amgen had woken a sleeping giant in Sanofi, because that should have been enough, right? Sanofi's off the hook. They didn't infringe, but Sanofi said, well, you woke us now. So Sanofi appealed to the Federal Circuit and basically said, especially on the written description and enablement pieces, and the Federal Circuit basically told the district court that they had given the jury improper instructions in telling the jury how to decide written description and enablement. So they remanded it back to the district court. The jury said again that it was valid for written description and enablement. The judge used kind of like a lesser known tool to kind of go over the jury's head and said, no, I disagree with you, jury. You've said this twice now, that I disagree that it's not enabled, but there is written description support. So then Amgen appealed to the Federal Circuit, which is what we're discussing today. And then, of course, as we know or see, it stands, that final decision from the district court stands. And so the Amgen appeals to the Supreme Court, which is yet to come. So this is, an older quote from an older case, but it says, to prove that a claim is invalid for lack of enablement, a challenger must show by clear and convincing evidence that a person of ordinary skill in the art would not be able to practice the claimed invention without undue experimentation. This undue experimentation tends to be read back into the statute, but it does not exist in the statute. We tend to say it is. So here are Amgen's claims for two other patents, the same written description. So claim one is a monoclonal antibody that, when bound to PCSK9, binds at least to one of the following residues, the PCSK9. So there's, I think, 15 residues there. And wherein the monoclonal antibody blocks binding of PCSK9 to the LDL receptor. Claim 29, this is just a representative few. I don't think I grabbed them all, but Claim 29 was a pharmaceutical composition having the same characteristics of claim 1, but it blocks the binding of PCSK9 to LDLR by at least 80%, so kind of a binding functional requirement. And then claim 1 of the 741 patent was, again, an isolated monoclonal antibody that binds PCSK9, where the monoclonal antibody binds an epitope on PCSK9 comprising at least one of those two residues, and where in the monoclonal antibody it blocks binding PCSK9 to LDLR. So they did have testimony that, so for example, there's two experts that testified seemingly. There was a Dr. Reese, and he testified that I don't believe, based on good protein structural principle, an antibody could bridge across without interacting with those amino acids in between. So that, and this was in response to them asking him if just one amino acid was enough, or if like two were enough on disparate sides of the binding pocket. And he basically said that I don't think, an antibody could bind just one and not hit other ones in between. But also that if it were only binding one, in a structural limitation, it wouldn't suffice the functional limitation, which is blocking binding of PCSK9. So their claim has these two facets of it, right? The structural piece and a functional piece that for, yes, their structural piece is such that it says at least one of, but then their functional piece brings in this added complexity that it has to block PCSK9 binding to the receptor. And so arguably just one amino acid, binding just one amino acid wouldn't fulfill the functional feature of the claim. So, right there might be a problem a little bit, right? Then why not claim at least 2 or 3 amino acids? But that's another discussion point.
Actually, I have a question about that. So, okay, claim 1 in 165, well, both of them are claiming an antibody, an isolated monoclonal antibody. Then they say, when bound to PCSK9, the monoclonal antibody binds to at least one of those residues. But that's already kind of like claiming a thing by its function.
Mm-hmm.
So that first half's already, am I getting that? It's already functional language in the first half, right?
Yeah.
There's no explicit step there, and there maybe should be.
But there's no structure. There's no structure of the antibody.
They do.
Yeah.
This is where, maybe, this is a 112F, means plus function discussion, but, they do, I think, have 26 sequence listings for antibodies in their spec and a few three-dimensional images of the antibody. So it does make you wonder if, to some degree, should their claims be limited to that then?
That's what I think, because this is preposterously broad to me. And it's not my field, but to just say an isolated monoclonal antibody and not explicitly say which antibodies, what their layout is, how they look, and they do have some examples of those. But if you transfer this to any other field, you can get what you disclose and their equivalents. And I'm not sure we know what the equivalent would be to this isolated monoclonal antibody. Well, just from their spec.
Yeah. What I think is, it's hard to define where proteins bind to each other, right? That's a really hard science. And then to make an antibody that very specifically targets that same pocket, I think is really hard. But if you were to, this is where I have a little bit of because if you were to really strictly claim an antibody structurally, your body's going to make 20 of them different next time you immunize, right? So it'd be really easy to design around because, it's, the antibody could bind any subset of these epitopes and still exhibit the same function. So that's where, I agree. And I don't know how you would do it, right? Because, because even if you said I guess you could say it's an IgG antibody, right? Because at least you're kind of, but, there's tons of subtypes of IgG. So is that enough? But then there's, so I don't know. This is where I have a hard time because to really claim, it takes so long to develop an antibody and then to be able to easily design around by just immunizing another animal and finding a different one, it would be a max couple year exercise.
And I think the purpose of some of this analysis and case law is, and the reason they're kind of pointing back at Amgen and saying, we don't like this, it's too broad, it's too this, too that, is they don't want to stifle future innovation by giving this sort of monopolized product, right? It ends up in a product to one player.
Right.
And I'm not sure that this claim does that, but I think that's the bigger concern. So then to get around that kind of concern in other fields, you end up describing more explicitly examples that could be used and more explicitly exactly the how of what you're doing. So the reason they brought in McRow into this, which is a software case, is because they are making a parallel to black box software that says, maybe I have a machine learning something that does these 5 things, but I never say in my specification what these 5 things are. And I also never say, like in detail, and I also never say what that machine learning system looks like. And when you begin to put that together, you have written description problems, but you also have enablement problems later, right? Because you don't have enough of the actual guts of what's going on.
Right.
And so this is more complex than that. So it's kind of peculiar to me that they dragged that in, but I can understand the sentiment.
Yeah, I agree with. As I was reading this case, I had the same thoughts, Kristen, you did, coming from other technology areas, because this also isn't my background. But then, Ashley, you just said something that is kind of like the other side of that coin, which is that how these biotech companies put tons of resources into developing these very useful drugs or antigens, whatever, and how do they protect them in a way that doesn't let their competitor just super easily design around it? It is an interesting question, but I mean, I totally agree with Kristen's analysis. Like from the patent law perspective, they're not teaching someone how to make and use exactly what they've said in the claim. So it does seem to be an issue.
Well, I would argue that they don't in the claim, but I think they do in the spec. So
no, I mean the spec doesn't teach the spec. Yeah, some exactly. So like there's a few. I think one of the again, this is not my field, so Ashley, correct me if I'm wrong, but I know one of the experts said you can't even reliably take a protein sequence and know how it will fold from first principles.
It's true. But again, I think that's a physiology problem. You know what I mean? It's like this science, the basis of these cases is antibody science. And that has been around for better part of a century. So that's highly predictable. But yes, protein chemistry and protein binding and protein three-dimensional, because proteins change shape too when they bind each other, right? There's these, it was always a joke in grad school. It's like, oh, it underwent a conformational change when you couldn't explain something. Because, proteins change when they bind to each other, and they, when they bind to receptors, receptors internalize, or they change shape, or they, all sorts of weird things happen that we don't understand.
I see it. I definitely see it's a tricky problem. This particular case to me seems like a land grab, though. It seems like they found a few things that worked, and now they're trying to grab the entire country. But like maybe again, it's not my field, but like if they had identified a protein structure of the antibody that bound to these particular residues of the PCSK9, and then they said, okay, the antibody has to have this, whatever DNA sequence, this protein, this amino acid sequence. That to me would be a little bit different, because now you're saying we found a thing. Sure, you can change a whole bunch of other stuff, but this is the key nugget that binds to these key residues. And that's what we found. And then you can, sure, anybody who just adds some junk on the end can't just copy that and design around it. But that's not what they're saying, right? They're saying, like, we found a few things that work, and now we're going to block anyone from finding anything else that works.
Well, and maybe they did this in their examples in the spec. And so maybe we have a handful of examples that do exactly what Dave is requesting. And so then the claim would necessarily be limited to those pieces and their equivalents. But how big is the and their equivalents, right? And how much is the undue experimentation in this field? Right. So that's another thing. I think this needs a redefinition of undue experimentation because of the complexity of this field.
Right.
But, I don't know how you do that in a court.
Yeah.
I don't know.
Well, I think the, from a blocking perspective, I think the interesting thing is that, Sanofi did create an antibody that performed a function that was different and didn't infringe. You know what I mean? So from a blocking perspective, it's not as it's not as broad as it appears, because Sanofi created an antibody that got around this. That was the first district court where they didn't infringe.
Mm-hmm.
Right. And so, I definitely see the point, but I also I wonder how blocking it truly is, because Sanofi was able to do it. Right. And with reasonable time frame. But all fair points. This is where I'm kind of bipolar on this topic, because in one sense, I'm like, gosh, the amount of time and money that they poured into this to get it. And then, to do point mutations of every of those 15 amino acids on LDLR to figure out which one is the important amino acid, that would take freaking forever to do point mutations, and what if the protein doesn't bind, doesn't fold well, then does it not bind? Is the antibody not binding because it didn't fold appropriately, or is it not binding because it's really not the right epitope? You know what I mean? It's like kind of a Pandora's box. So I also get, not doing all those point mutations to figure it out, but yeah. So some of the things that the Federal Circuit did say was that the binding limitation is itself enough here to require undue experimentation. So the whole idea that, screening these things for a binding limitation would be a lot of work, right? So even if you found a whole bunch of antibodies, that you'd have to figure out their binding feature, right? So, and then the Federal Circuit also said, we also agree with the district court that this invention is in an unpredictable field of science with respect to satisfying the full scope of the functional limitations, which I would disagree a little bit, because if we go back to N. Ray Wands, they said that this was like a highly predictable field. Same field 30 plus years later, and now they're saying it's unpredictable. But yet antibody science is highly predictable. At least it wasn't in Ray Wan. So I feel like there's a little bit of a
Yeah, how big does this have to be before it becomes unpredictable again? Right? You're saying that the experimentation that would have to be done to just identify what was going on in the Amgen claim, basically, is really involved in extremely lengthy of time. So does that become more unpredictable as that gets larger?
I don't know, because
prove it.
Does complexity and length of time mean unpredictable, or does it just mean, having patience in the process? Right. And that's why I wonder with this case too, a little bit, is that, yes, it's like a long process, and yes, you get a lot of hits, but there is well-known screening methods, well-known creation methods, well-known. So is it just that people don't want to go through this lengthy couple-year process to design around and build upon? Or is it really undue experimentation? I think there's like a patience versus unpredictability, like true unpredictability question.
Okay. And that maybe wouldn't be undue experimentation, because that's just what's required to find out this information.
Right. And actually there's that interesting, so I have some quote later. Yeah. So this is the interesting part from one of their experts. They had another expert, Dr. Jackson. So in the Amgen patent, they disclosed a roadmap for how to make these antibodies. And their Dr. Jackson expert said the significant similarity between the research plan used by Dr. Jackson and the roadmap disclosed in the patent demonstrates that a person of ordinary skill in the art attempting to obtain a claimed antibody that is not disclosed, or is a variant of a disclosed antibody, would have to do essentially the same amount of work as the inventors of the patent in suit. And I think that's okay. If you have to do the same amount of work, that's the whole point of the patent system. You're not given something for free. You got to do the same work, but you're guided. And so they used that to say that it creates undue experimentation. And I would actually argue that it's the opposite, that just because you have to do the same thing doesn't mean undue experimentation. I mean, it actually means that you did a really good job of describing it, and it's just a crappy long process. So I found that really interesting. And disagree with their conclusion there. But yeah, I mean, I think it sounds like they gave a really good roadmap, and actually the roadmap that their expert put together versus the roadmap in the patent were super similar. And so I don't think that's unconventional, or undue experimentation. I think that it's just a long, arduous process. And if you want to compete in the space, you're going to have to go through the process,
When you said something there, physiology is unpredictable, but the prior slide, you're looking at the antibody technology being unpredictable.
which I don't think it is. Like that's what I would argue that it's not.
I wonder, and this is all kind of coming together, right? Like, Ashley, what you were saying, I think, was that, and Kristen, what you were saying, let's just assume for a moment that the specification, because there's tons of sequences in there. So the specification does provide a bunch of different antigen sequences that are starting points. I guess maybe if the claim was interpreted with the 112F type, with means plus function type considerations, now you wouldn't say this is any antigen that binds to to these residues. These are the antigens that we have disclosed because it's means plus function. So I think I wonder if really, like, if you have this good starting point, and I know good is it's all relative, right? But let's say you have a good enough starting point that you know what antigens you're trying to test. Then you make those antigens. And now I think, Ashley, you're saying going through the screening process is routine.
Right.
But I think an issue comes in when you don't even know what antigen you're starting with. If you just have no idea what protein sequence you're starting with at all, and you just need to make that up from scratch, make every possible protein sequence in the world, and then test them against these residues, clearly undue experimentation. There's no way no one would know how to do that. But it comes back to the spec. And I think, Ashley, what you brought up is a really good point. If this is 112F, it means plus function type language, now you do have a good starting point, which totally, I think, changes the calculation about how much experimentation is needed.
And actually, I think you bring up a good point too. I mean, from from a nomenclature perspective, you were using that. So antigens are kind of what are used to inject the rabbit, and then the antibodies are what are created in response to those antigens. I wonder if that's another way, because I think they disclosed a whole bunch of antibody sequences, but maybe
antibodies.
No, it's okay.
Yes.
So they did a whole bunch of antibody sequences, but I wonder if another way too would be to provide the antigen sequences, right? What are the chunks of PCSK9? And, and maybe they do. I don't know. I can't, I don't know if they did.
That's what confused me, because some of their protein sequences are antigen binding proteins. So I interpreted that, because I'm not an expert, I interpreted that as part of the sequence of the antibody.
I have to look at antigen binding. Say it again, antigen binding.
Antigen binding proteins, light chains and heavy chains of antigen binding proteins.
That's the light and heavy chains. So that's these.
Okay. So those are antibodies, but those are sequences of parts of the antibodies.
Mm-hmm.
Okay.
Yep.
Okay.
Yep. Yeah, because this is, like I said, this is a fixed region based on the class and subclass of the antibody. So like IgG1 has their own IgG2. So anyways, I kind of went through this and did my own Watts factor analysis, open for discussion. So, quantity of experimentation necessary. Again, I think antibody generation is well known. It's like I said, it's been around for a better part of a century, but physiology is unpredictable, right? If you inject the same thing into a rabbit that they injected, are you going to get the same thing? No, because is it the same strain of mouse or is the same strain of rabbit? Has that rabbit seen other things that your rabbit hasn't seen? Is that, there's even vendor differences, right? We even saw when we did research that C57 black mice from one vendor had different things, behaved in our experiments differently than a C57 black from another. They overall behaved the same, but there were some like nuanced differences where you're like, these mice are not, they're supposed to be genetically identical, but they're not. So I think that just physiology is unpredictable, and I don't think we should punish companies for physiology being hard. Amount of direction and guidance. I think they did give a lot of guidance. I think that's even admitted to that they gave a lot of guidance. They had a roadmap for creating these. They had working examples. Was it enough? Did it show enough species, enough representative species? I don't know. The nature of the invention, state of the art. I think it kind of follows with the other ones. I didn't go too deep into those. The relative skill in the art, I think, they even admitted in Ray Wan's, again, 30 plus years ago, that the skill in the art was high at that time. So I would argue that the skill in the art is still high for antibody science. And then again, physiology is unpredictable, but I would say that antibody science is, for what it is and for how long it's been around, it's not that unpredictable. You inject a rabbit or a mouse or whatever, an animal with something, you're going to get B cells that are going to react to that. You're going to, you're going to be able to get them out. Now, is it going to be the exact same thing that Amgen created? No. But again, that's the physiology, the unpredictability part of physiology.
So I have a comment on that.
Yeah.
I have a quick comment on that.
Yeah.
It's possible that when Wands was putting this predictability or unpredictability of the art up, they meant literally defined predictable arts and literally defined unpredictable arts. And so typically this kind of science falls into unpredictable arts. So maybe it wasn't explicit about what they were doing, but that it was categorized in this unpredictability field.
Yeah, maybe a little bit, huh? Or at least would weigh into the analysis.
Yeah, similar kind of question is, Ashley, when you say physiology, are you including both parts of the claim? Are you including that first part of the claim where antibody binding to a residue, is that part of physiology or is that not part of physiology?
I don't think that's I don't think that's unpredictable because it's, PCSK9 does bind to LDLR and it's in that pocket. So if you can find something that prevents that binding, it's going to be in that pocket, right? So
is it if you were shown a 3D structure, let's even say, of an antibody, would you know whether it was going to bind to one of those things?
No.
That's why I think it's unpredictable. Like you might be able to make an antibody, but making an antibody that does what you want it to do is unpredictable. You have to do it by experimentation, right?
Right. But, if they teach, but that's the whole, like they're teaching with the guidance, right?
Right.
And so
but it's still unpredictable, even though they've taught some things about it. Yeah.
It's a hard one for sure.
Yeah.
Chris had to hop off. She's an examiner call. And we'll try to wrap up here a little bit too. So breadth of the claims, again, they were reasonably broad. They did identify specific amino acids, but there probably could have been some, gut check and saying, kind of like what their experts said, you probably can't find an antibody that's only going to bind one amino acid and inhibit function. You probably do need 2+, 3+ amino acids. They probably should have been more realistic in that, at minimum, in that sense that, an antibody binding just one amino acid, I don't know if that's really a thing. So then the representative, so for the written description part of this, obviously the Supreme Court's taking up the enablement piece, not written description. But, in reviewing the district court, what they had said, so there's the representative species test, and they looked at, amino acid sequence similarity, 3D structure, and all kind of found that Amgen's and the compare antibodies were structurally similar. So interestingly, even though Sanofi did not infringe Amgen's claim, their antibodies were structurally similar when they looked at them. And there was 80% similarity in amino acid sequences between Amgen's and competitor antibodies. But interestingly, Amgen's disclosed antibodies covered more classes of antibodies. So I think that weighs in favor of the whole representative species because it wasn't just, I think it was probably still all IgG would be my guess, but maybe not. Maybe there's some other ones in there, but it covered a good swath of classes, which I think goes towards that representative species. They say just a monoclonal antibody, but they showed support for lots of different classes. And then they had substantial evidence showing that while binding to different residues across the sweet spot, that they blocked PCSK9 binding to the LDL receptor through a variety of binding interactions. So I think that's interesting too. Sounds like, at least based on this, that they had some data to suggest that their different antibodies that they had created did bind in that sweet spot, but in a few different ways. So maybe that lends itself more to a broader claim too, the fact that they were able to, all bind in that sweet spot, but bind in kind of a little bit different ways. So, but just in general, thinking about this, this was a quote back from Ariad versus Lilly in 2010. The Federal Circuit basically said there was little difference between describing an invention and enabling one to make and use it, and that written description and enablement often rise and fall together. So I'm kind of surprised that the Federal Circuit has reviewed these things in isolation and that the Supreme Court is taking these things up in isolation. Because honestly, the more I dig into this world, the more I don't think they should be separate. I don't really, especially when both parts of the statute say, the written description should allow somebody to make and use it, and enablement should allow somebody to make and use it. I don't know. I would love, I I don't think that this is a good example of a case where it does one or the other, because I don't know if they can be separated, but that's my personal opinion. Oh, and this was so I'm going to read this just because it was if you have a chance and you're curious, if you go back to the Ariad Pharmaceuticals versus Eli Lilly 2010 Federal Circuit decision, former Chief Judge Rader gives an amazing dissent opinion, which like encapsulates, like I wish I would have read this several days before instead of just like this morning, because I'm like, oh, this is like my feeling on it. But this is what he says. So the language that the majority uses to explain possession as shown in the disclosure not only fails to justify a separate test, it also fails to distinguish the test for written description from the requirements for enablement. The level of detail required to satisfy the written description requirement, according to the majority, varies depending on the nature and scope of the claims and on the complexity and predictability of the relevant technology. These considerations, however, mirror the WANS factors for enablement, which include the things that we've all seen. The court attempts to distinguish enablement by observing that although written description and enablement often rise and fall together, requiring a written description of the invention plays a vital role in curtailing claims that do not require undue experimentation to make and use and thus satisfy enablement, but that have not been invented and thus cannot be described. Yet, if a person of ordinary skill is enabled to make and use a novel and non-obvious invention, clearly recited in the claims, I fail to see how that invention can be said to have not been invented or be in some need of some undefined level of additional description. It is inconsistent to say that on its filing date, a patent does not show that the inventor possessed subject matter that the claims actually encompass and the specific specification fully enables. And the other interesting piece of history that I learned, so prior to 1836, your whole invention was just described in a written description. There was no claims. So the written description was the claims. And then it was only after with the 1836 Patent Act that claims started being a part of how we draft patent applications. And so those claims served the purpose of distinguishing the invention, while the specification as a whole must enable. So that was kind of the thought process around, I think, written description and enablement, is that, before everything was in that written description, but now they kind of pulled it out to distinguish the invention versus enabling what the claim said. But maybe I think those lines have blurred a lot. Anyways, I don't know if we have time for these. I mean, we've kind of talked about these. Can we separate enablement from written description? And if y'all have any thought, I don't think you can, but there's a lot of blogs out there that think you can, and some judges clearly think you can. Chief Judge Rader doesn't think you can, but I don't know.
I think we all agree with you, actually.
I don't know. So the more I read it, I get the intent of it, the whole possession versus making and using it, that's what examiners say too, right? Like if you have some weird things in your claims, they say, I don't know, the inventor possessed it and stuff. But I just don't know if you can really separate them. And that's actually what concerns me about the Supreme Court taking it up, because they worry that they're just going to muddle it more than they're going to clarify, because they are only looking at enablement and they're not looking at written description.
Yeah, that's a good question. They seem really similar. I mean, are there some subtle, is it a genus species thing? I'm not sure. Yeah.
Right.
Just sort of as a summary comment while you're looking for that, this Amgen patent has a ton of examples in it. When you start looking into all the sequence IDs, there's a ton of examples, and they even line up various protein sequences to show similarities. And there is a lot of guidance, right? So with the means plus function claim interpretation, including, as we were talking about, what's the word? You have its equivalence. So you've given a ton of examples, you've given some roadmap. Now you get everything. Let's say it's a means plus function claim. So you're only entitled to what you've described and the equivalence.
Right.
So if they've described it well and described some of these common features between their different examples, you would imagine that any other antibody that has those common features would be equivalent in some definition of it. So it gets really complicated. And I think, Ashley, I totally see your perspective as what's the role of the patent system? We
Yeah.
need to allow company, we need to foster innovation, and allow companies to leverage their work and prevent other people from just copying them. And then, as Kristen brought up, you can't have land grabs either, because
Right.
that doesn't foster innovation
No.
either. So it is a tough question that comes down to the specific facts of the case, right? And
Hmm.
hopefully the Supreme Court will drill into those facts and do the right analysis.
Yeah, 100%. But I think it is like, I think to Kristen's point too, that it's probably gonna be highly dependent on each art, but I think what does have to be remembered by the courts and inventors alike is that, the patent system isn't meant to make innovation and designing around easy. It's meant to provide you a path to do it.
Yeah.
Right. And so some sciences just take a long time to do, even if you have a perfect roadmap and perfect, protocols. Some of it just takes a really long time to do. Especially in the pharmaceutical, antibody, whatever world, like it's a long horizon, no matter how much you're taught, right? But that doesn't mean that it's undue experimentation. And it'll be interesting to see if they take that up in the Supreme Court too, or whether Congress does at some point, because that's not in the statute. Again, that's one of those things that have kind of been read into the statute that doesn't actually exist in the statute. I mean, it's kind of precedent, right? So what's the role of that? And how codified is that going to be?
I was curious, and I don't really know the difference in mechanics on as far as levels of the courts, but who composes the jury? So is that people with ordinary skill in the art, or
That's a good question.
I mean, because this is I seen a glimpse of it as it all went over my head, but if I was on that jury, I would have a pretty hard time.
Right. Kyle, you mean just not in like in a normal district court case, who composes, who's in the jury? Yeah, just like any jury, average citizens, right? Normal people.
That's where I think. I think that's where I think the court system fails the patent system, is that even with the Supreme Court, I don't think it's any secret that a lot of the people who are in the different courts, and even like this, the juries and stuff like that, they're not read into the level of detail they need to be to, one, understand the technology necessarily, and then make decisions around that technology. So I think a lot of judges in courts show their lack of understanding. And so, sometimes when you hear them, when they write these opinions and stuff like that, so does beg the question, like, should the jury selection process be different for patent cases? Should it be, do you have some people that it's like normal lay public, but then do you have a special bank of people that you pull from? I don't, that somehow that's like it's a mixed bag. I don't know how you would do that.
I know what you mean, Ashley. It does seem like a lack of technical understanding can lead to some poor decisions at some of these levels in some of these cases. I think what one would say would be that's the role of the experts. Both
to bring
sides
it down.
get to put their expert forward, and they get, their questions are asked of them, and the jury and judges are interpreting what these experts said. But yeah, I'll just say I agree with Ashley that the lack of technical understanding of other parties involved does lead to some weird results sometimes.
And you've been a part of some expert testimony kind of stuff, Dave, too, haven't you?
Right. Yeah.
Have you been part of an actual, have you been is there an education piece for the jury? Does somebody sit up there and say, kind of like what I did here? I mean, but like, here's antibodies, here's what they look like, here's what they do, here's what they mean, to kind of bring people along? Or is it kind of like, here's the deep end, here's our expert, good luck?
Right. I believe, it's a little bit up to, I think, the prosecution and the defense for what they present. I think the instructions given to so I've been involved in arbitration Case is not. Nothing that ever went before a jury and a judge. So I don't have a direct experience with that. But I think that it's up to the prosecution and the defense and what they present, the evidence that they can be overall general education about how antibodies work. That could be something that they could present. I think, and you brought up that the instructions to the jury weren't quite right. I think what the jury does get instructions on from the court itself is the law. They're explained what the laws are, but they're not explained about the technology, I believe, outside of whatever the two sides choose to present.
Interesting. I feel like there should be like you're selected for this jury. Now you're going to spend a few hours listening to, some expert, just some random person, you're right, that's not embedded, in bed with anybody or whatever. And, you can have legal counsel, in that room to make sure nothing is said that would sway anybody, but just give us a 1 to 4 hour deluge on this technology, right? Like, I feel like there could be benefit maybe from that.
Now, some litigators are going to comment on this podcast saying that we all don't know anything about litigation. We have no idea what we're talking about.
Probably. Listen to these chumps over there.
Right.
But yeah,
I just can't help but think. So I was in a jury trial Friday, and I mean, it was extremely cut and dry. Some of the most simple instructions that you could imagine, and there was a pretty hard time interpreting that. And so I'm thinking of this, and I'm like, I just don't know how you get there.
You need to read the district court case for this, Ty. Yeah. Yeah.
Yeah.
I think you'd have to read it 16 times to get the full lay of it. But, yeah. So then the other quick thought I had, again, nothing too crazy, but is just, would it have been better to not include functional requirements? Because it seems like a lot of the recent enablement issues, Idenix, Wyeth, Enzo, all fell because they had these functional requirements that seemed to create uncertainty, at least in the eyes of the court, for screening compounds that were covered by the claims. So I do wonder if, I don't know how you would otherwise claim it, right? Because without it's even broader, but I don't know. It seems to be a red flag a little bit when you start putting that functional stuff in there.
There's a quote in this case: while functional claim limitations are not necessarily precluded in claims that meet the enablement requirement, such limitations pose high hurdles fulfilling the enablement requirement for claims with broad functional language, right?
Yep.
So yeah, they exactly. The judges agree.
So anyways, that was kind of it. Yeah, so this is from the MPEP. I like this probably was an unfinished part, but enablement serves the dual function of ensuring adequate disclosure of the claimed invention and of preventing claims broader than the disclosed invention. Broad claim language is used at the peril of losing any claim that cannot be enabled across its full scope. But again, that's the MPEP. And I think this could be a whole nother thing that we're not going to go into today, but the other part that's been bugging me lately about patent law is that there's court precedent that is binding based on laws. And then there's the MPEP. And some of the MPEP is based on court precedent, but some of it is the world that the USPTO wants it to be and not as it is, or how the USPTO perceives it to be, but not as it is. So if you strictly follow all the things of the MPEP, your patent practice isn't going to be great, because the MPEP tries to mirror court precedent, but it still is an administrative body's interpretation of court precedent and a group of people that no court has signed off on, right? And so there is good tidbits in the MPEP that are directly tied to case law. There's other things that are said like this, which I don't know if this ties back to any court case or any precedent. You know what I mean? I don't know. Anyways, that's my beef. There's like a paper that just came out by I don't remember who, but it's like sitting in that I want to read now. It's about that whole thing of like some stuff is actually based on precedent in the MPEP. Some is just the USPTO's interpretation or how they want the world to be, but not as it is. And if you follow that strictly, you're probably going to be in trouble. So anyways, I'll get my soapbox for today, but thanks for the good dialogue, everybody. And some really great points. I don't know if we solved the problem, but we definitely, provided a good quagmire.
Yeah, thanks, Ashley. That was great.
Yes, good job. Very good.
Thanks for participating, and we'll see you next month.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.